So we've already discussed the fact that the federal rules take a very liberal approach to what it is that a claimant has to show up front, just a short and plain statement of the claim. And so that would seem to be very plaintiff-friendly and allow the plaintiff simply to make a basic statement that would have enough information to state a claim, and that's really all that's necessary, no extra evidence and things like that. And that was really where things stood until 2007, when the US Supreme Court decided a case called Bell Atlantic versus Twombly. So let's talk a little bit about that case. So Matt, just give me a little summary of what that case is about and who's suing whom.
Sure. So the incumbent local exchange carriers, which are referred to as ILECs.
Too much detail. Talk to me in normal person's language. No, not legalese. So who's suing whom and why?
Sure. The phone carriers were supposedly not competing for territory, for local coverage. So users of the phone carriers said the prices were too high and brought an antitrust action because the different carriers weren't competing for price.
So you had all these phone carriers, and they basically, within any given geographical region, only one carrier is available. And we see the same thing often with regard to cable companies and broadband now, where you have relatively little competition because in any given geographical location, you only have one choice or maybe two choices with regard to the corporation. Is that an antitrust violation in and of itself, Jamie?
No, in and of itself, you can't just say that there's conduct that is anti-competitive. You have to prove that there's an agreement between the parties to be anti-competitive.
So one of the things that's interesting in this case is you have behavior which could be legal or could be illegal, depending on why that behavior was entered into. So, for example, if these two companies, let's say they're two pizza companies, and one of them wants to operate within a 10-block area of their location, and another one wants to operate within a 10-block area of their location, and they don't overlap at all, the fact that they don't cut into each other's market is not an antitrust violation. It's just a business choice that the two of them made. But if the two of them got together and said, you take these 10 blocks and I'll take these 10 blocks, then that's a potential antitrust violation. And so it's the same behavior, but it depends on whether there was a collusive intent behind it. Was there any evidence shown in the complaint, Catherine, that there was collusive intent here?
There is one indication made by the CEO of one of the ILECs saying that it would be basically an easy way to get a quick dollar to move into someone else's territory, but that doesn't make it right, meaning that he at least acknowledged the fact that there was some reason not to intrude upon other ILECs' territory.
So there's a little bit of information that they've at least in emails talked a little bit about the fact that there were kind of territories, but not much more with regard to them getting together and actually colluding. Although, it's hard to come up with that. What would be evidence, do you think, of actual collusion that they might have at this stage?
If they ever caught it on film, like CEOs of the companies discussing territory with each other.
Right, so you could have some smoking gun video of the CEOs getting together, or if they were stupid enough, emails that they sent to each other saying, you have this territory and I'll take this territory and so forth. That presumably could be an antitrust violation, but it's very unlikely that the plaintiffs are going to have that information. The information doesn't exist, but even if it existed, it probably exists on the email servers of the corporations that are involved, which the plaintiffs don't have access to, at least at the beginning. So without discovery, you're really not going to have anything much except this sort of odd fact that they all are divided up by territory. So the question is that complaint good enough under Rule 8 to say, look, I notice that they're all divided up in territory, and they know that there are territories, and I think they've colluded. Is that enough according to the court?
The Supreme Court in this case says that it is in fact not enough. They say that although the plaintiffs have alleged what they call conscious parallelism or this behavior, that they actually have to add more facts that would suggest an agreement. And the court calls it, like, the plaintiffs have to allege something that's plausible and not merely just sufficient, that like it could possibly be that they require a plausibility standard.
Okay, so let's go back to what we were talking about earlier with regard to Catherine's discrimination claim. What would it be to say that, what would she need to show, or what would we need to show in this case to make it plausible as opposed to, I don't know, possible? Like, what do they mean, do you think?
Well, I think this is why I disagree with the court a little bit in this case, because it seems to me that the parallel behavior could in fact plausibly prove that there was an agreement, but obviously the court is looking for a little bit more in this case and would also be in a discrimination case. So it wouldn't be enough, I don't think, just to say, I think Professor Berman was discriminatory against me because he filed this claim. She would have to, I think, have some other fact, perhaps that you made a statement that was discriminatory against women, or a little bit something more that would suggest actual discrimination in the case.
Yeah, it seems as if they want something more, although they do go out of their way to say that this is not a heightened pleading standard. They're not overruling Rule 8, so it still is just a short and plain statement of the claim. It's just a short and plain plausible statement of the claim, I guess, something like that. Do you think, Matt, could you make an argument that this only applies to certain cases and not necessarily all cases? So for instance, if you were a lawyer in a future case, you're a plaintiff, let's say, and the defendant says, under Twombly, I win because you haven't provided enough information. Is there any way that you could argue that Twombly is specific to its facts?
Well, I think they were arguing that Twombly didn't really change anything. It was just giving the defendants enough facts to be able to create an adequate defense, and just to, as the rule said, like let them know what the complaint actually is. And I don't know why this quote was cut out of the case snippet that
Where are you looking?
given, but in note 5, there's a quote from the Twombly case that the complaint furnishes no clue as to which of the 4 ILECs supposedly agreed or when and where the illicit agreement took place. Knowing that, now it's really clear what facts they wanted that were missing. There was no factual pleading of any sort about the actual agreement, which is supposedly the antitrust violation, which needs to be brought.
Okay, but if you so let's assume, let's say, Jamie, you were representing the plaintiff, and the defendant says, "Oh, well, you haven't provided information up here as to when we met and we actually did this collusion." What would be your response to that here at the complaint stage?
Well, if I'm representing the plaintiff, it doesn't matter when you made the agreement. The fact that you made the agreement is what's illegal. So I don't think I would have to specifically, I don't think it should be the plaintiff's burden to say on X date you agreed with this other person. I think it would be enough to say that these people made an agreement to collude and they colluded.
And indeed, you may not know when specifically they met. You might think, well, sometime in the last 2 years they must have met, but you may not know when it was and exactly what the agreement consisted of. Certainly, again, not without discovery. But the court seems to say that they don't want there to be a fishing expedition where you could just allege it and have that allow you to get into a long discovery process. And And indeed, here, this would be a very long discovery process. Catherine, why would this be why would the court be particularly worried about the extent and scope of discovery in this particular case?
Well, because it's a phone company, and in general, I think with larger corporations, there is a tendency for small plaintiffs to maybe use pretext to sue a larger company for, as we discussed earlier, settlement. And I think when otherwise legal behavior rests on an inference of improper intent, with a big corporation, they would be subject to suit all over the place and potentially all the time.
So Catherine raises two potential concerns that the court might have here. One is that this is kind of a case that's going to lead to large discovery. It's a lot of large corporations, lots of activity, lots of corporate behavior, and so forth. And so there's the potential for it being a very burdensome discovery process. And secondly, it is a particular kind of suit which, as we discussed earlier, is behavior that is legal if entered into for one reason and illegal for another reason. And so it rises or falls solely on motive. And the problem with cases that rise and fall solely on motive is it becomes relatively easy to say you engaged in lawful activity, but you did it for a bad reason. And by tacking on the "but you did it for a bad reason," you end up with suddenly you have a lawsuit just based on that little sentence. And so the court may be particularly worried in those kinds of cases about just a bare allegation getting you from lawful activity into an extensive discovery process. And it may be in other kinds of cases the court might look at it differently. So I'd like to turn to the online student, and I'd like to ask you to write a couple of paragraphs. And the first paragraph, I'd like you to answer whether you think the Twombly case was rightly decided. Do you think the court struck the right balance in this particular case in kicking this case out? And you can use the arguments that have been made here as well as other arguments that you might think of on your own, and also address counter-arguments. Then the second paragraph I'd like you to write is if you had another case, let's say a breach of contract case, where one party says, you didn't do this thing that you contracted about, and the other party says, yes, I did. I want you to ponder whether you think the Twombly decision would apply to that, or whether there's an argument you could make that Twombly does not even apply to that kind of a lawsuit. And so you can argue either way, that Twombly should apply or that Twombly doesn't apply. But if you, whichever way you argue it, I want you to use the Twombly decision to either, and use the facts of the Twombly decision to either distinguish Twombly or apply Twombly to your breach of contract case. So try that now.